I would like to start this presentation, Copyright Basics Part 1, by saying that it is not at all an exhaustive study of copyright. It is meant to serve as a guide for helping designers to know what their rights are as content creators and helping them to avoid copyright infringement. It is best used as a gateway for determining what considerations should be made when finding content for graphic design work. Copyright falls under a larger umbrella of law called intellectual property law. Intellectual property refers to a work or invention that is the result of creativity, such as a manuscript, photography, or design, among many other things. Copyright is not something you have to apply for. It exists immediately when the work is in fixed form, meaning that it has to be recorded in some way, either written down by hand or digitally, recorded in audio or video, emailed, etc. If it only exists in your head, it is not protected. As a content creator, you have the rights to reproduce your work in any form, prepare works based on your work, distribute any copies of your work, and display the work. Anyone doing any of these things without your express written permission is in violation of your copyright. Copyright law has been changed over the years. We aren't going to go into the history of copyright, so we'll take a look at the most recent law, which was established in 1978. A work that was created, by that we mean fixed in tangible form for the first time, on or after January 1st, 1978, is automatically protected from the moment of its creation and is ordinarily given a term enduring for the author's life plus an additional 70 years after the author's death. So basically, if you create a work, whether it's a photograph, poem, song, or design project, you own the copyrights to that work. There's one catch, and that's called work for hire. Work for hire is defined as a work prepared by an employee within the scope of his or her employment. If you are working for an agency or other company, your work completed on the job would fall under work for hire. The copyright would not belong to you in this instance, but to your employer. There are cases where content creators might want their work to be made available for public or other creators to use. Copyright holders can release their work and set parameters on the use of that work in different scenarios. If an image that you would like to use does not have expressed written permission viewable to you with your own eyes, you cannot determine whether it has been released. To use that work would be a copyright infringement. Infringing on someone else's copyright is a serious issue. It is illegal to steal someone else's work, and it's uncool. I want to address a couple of misconceptions about using the work of others in your own original designs. The rub with this is that in an academic setting, it's contrary to what you've learned about utilizing outside sources to support your academic work. In most cases, as with writing, you can give credit to the original source and be within the plagiarism guidelines. This is not the case when we're discussing copyright infringement because you will soon be, if you aren't already, creating visuals that are not just for classroom purposes. A lot of times we find images we need for presentations by doing a simple Google search. Google creates an inventory of what exists on the internet and shows results based on search parameters. Google does not verify whether these images in a search have been copyright released or not. It is not sufficient to Google and use an image form from its research. We must always view the expressed copyright release ourselves to be free and clear of copyright infringements. Even after learning about copyright, it can still be difficult to wrap our minds around what we can and cannot do with the work of others. This is a list, though not exhaustive, of things that should not be done without the express permission of the content's copyright owner. No use of logos, no use of imagery from movies or TV shows, no use of unfiltered Google search results, no use of images from an organization's website, no use of audio, songs, or soundtrack in distributed work, no burning CDs or DVDs, no playing movies in front of large crowds, no charging for entrance to view a live TV show. So it's clear that we shouldn't steal other people's things, but how can we know that we're not infringing on someone's copyright? We'll cover that in the next part of this lecture.